How presentment, dishonor, and discharge really work under UCC Article 3. Presentment, dishonor, and discharge, 3 steps that can cancel a debt under the Uniform Commercial Code, but almost no one understands how they really work. In this video, I'll break it down so you can finally play the system by its own rules. To effectively navigate the financial and legal systems as a private creditor or informed respondent, it is essential to comprehend the legal mechanisms of presentment, dishonor, and discharge as defined in UCC Article 3. These are not abstract doctrines. They are legally binding procedures through which obligations are extinguished or transferred. The operative language begins with UCC Section 3-501. Presentment means a demand made by or on behalf of a person entitled to enforce an instrument, to pay the instrument made to the drawee or a party obliged to pay the instrument. In plain terms, presentment is the official act of tendering an endorsed negotiable instrument, such as a promissory note, bill of exchange, or payment voucher, to a payee or creditor. The delivery can be physical, in person, or procedural, via certified mail or bank clearing systems. This demand is not a request. It is a formal notice invoking UCC protections. If the party receiving the instrument refuses to accept it, this constitutes dishonor, governed by UCC Section 3-502. An instrument is dishonored when presentment is duly made and the instrument is not paid or accepted. Once dishonor occurs, the law activates secondary liability and legal remedies for the party tendering the instrument. Under UCC Section 3-414, the drawer or endorser may be released from further liability if presentment and dishonor are duly recorded. Moreover, the creditor, now in dishonor, may lose their standing to collect unless they initiate judicial enforcement, at which point they are subject to counterclaim and estoppel defenses. This sequence unlocks discharge under UCC Section 3-603. An obligation of a party to pay the instrument is discharged by payment or satisfaction to the holder of the instrument. Here's where most people misunderstand discharge. Payment is not defined as fiat currency under UCC. Rather, payment refers to the performance of the obligation by means of an accepted instrument. If your endorsed promissory note or bill of exchange satisfies the obligation and the creditor fails to accept it, you may be entitled to discharge and damages. Legal scholars have long debated whether the Uniform Commercial Code leans more toward equity or strict liability. However, Article 3 functions with surprising clarity. If an instrument is negotiable, it is properly presented, and it is dishonored without cause, then the obligation is deemed satisfied, and any attempt to continue collection constitutes fraud, conversion, or unlawful enrichment. For litigation purposes, a certified mail receipt or proof of personal delivery may serve as prima facie evidence of presentment. If ignored, a notice of dishonor may be issued under UCC Section 3-505, thereby perfecting your administrative record and preserving rights to sue or counterclaim. Footnote: this section explains how financial obligations can be lawfully discharged under UCC Article 3 by correctly executing the processes of presentment and documenting dishonor.